Pole ndio hao chukue. Haya mbio. Wiko. Sawa? Haya.
So we have Joshua Nganga Baruya.
Good afternoon, Your Honor.
Good afternoon.
I believe my client is in Bahati police station. I wish to be placed on record for the accused person. We are ready to take plea.
Bahati police station. Accused admitted to bond of 200,000 without directions.
Yes, Your Honor. Yes.
Newton?
Good afternoon.
Yes, good afternoon.
The matter can be placed as on record, but it's wrong. I do appear alongside Senior Counsel Matoke. We do represent the accused on the dock.
So where is the applicant? So swear. Can swear. Sorry, just a minute. Do you have similar applications?
I'm number 76336, Corporal General del Congo. I'm currently based at DCI in at least. Your Honor, I'm investigating a case of incitement to violence where the respondent was arrested on the 26th day of January 2025. Your Honor, at the time of this arrest, I was not able to complete investigation. So I'm praying this Honorable Court to issue me 14 days to have the respondent remanded at Njoro Police Station to enable me record statements of key witnesses I'm here to conduct an identification parade. I'm also here to fill P3 form for the victim who was injured during the demonstrations. I'm also here to escort the mobile phone of the respondent to Safaricom to retrieve the call data. Donna, I believe if the respondent is released, he will cause further incitement to members of the public. At the moment, the respondent has no fixed report, Your Honor.
Yes, Your Honor, we reiterate on the position that Corporal Jonathan Chapong is saying that we request for 14 days custodial to enable us conclude on investigation. As counsel has alluded, this is now a public interest matter which requires thorough investigations, and due to the strict constitutional requirement of accused person brought within 24 hours, we could not be able to meet the said requirement. That's why we are before you requesting that you grant us the 14 days, as these investigations cannot be conducted while the accused person is outside, out of custody, for obvious reasons that he will interfere with the investigations. Your Honor, we request that you grant us 14 days. Accused person, the suspect be remanded at Njoro Police Station.
I understand there are similar applications.
Yes, Your Honor.
Maybe we can just hear all of them and then I make a ruling, a determination in all of them.
Criminal miscellaneous case number 76 of 25, Republic versus Isaac Fabian.
I said before this honorable court, the truth, nothing but the truth.
Yes, proceed.
Yes, Your Honor, number 93311. PC Richard Tataya, currently attached at DC Nakuru East, performing general investigation duties. My prayer to this honorable court today, Your Honor, I'm investigating a case of incitement to violence contrary to section 96 of the Penal Code, and my prayer today is to give 14 days for the respondent to be remanded at Molo Police Station to allow me to finish investigation. Reason being, I'm here to conduct an ID parade to get a data from Safaricom, Nairobi, get the P3 form for the injured victims, and record other key witness statements.
Yes, yes, ma'am. Okay.
Your Honor, in secret evidence, I don't know if it will be known that we use the same, because we are going to submit similarly to miscellaneous number 72. I don't know if it will be known that we use that, the 72 one as the leading miscellaneous file, but I want the court to guide me.
So they have similar applications?
Yeah, the same grounds, similar albeit the police station of detention, but everything else from a brief Peruso is similar to the first one. The issue of ID parade, the issue of forms and PT forms. Instead of taking a lot of court's time, all the miscellaneous be called, and then we need to use 72 as the lead file.
So do you have another file?
Criminal miscellaneous case 75 of 25, Republic versus Stella Nekisa Wairing. Criminal miscellaneous case 74 of 25, Republic versus Johnson Kamau, John Jabis, Peter Muhammad.
Okay, so what the advocates are saying, the applications are the same, so there is no need of you repeating. Okay, these are all the applications we have.
This is all of the applications. We shall be praying that the persons be admitted to a custody of 2,000. And further, with the directions of the court, we do have those persons report at the respective police station and need to be called to lead the investigation if the court takes that direction.
Okay, so give me about 10 minutes, I make my ruling. I can adjourn for 10 minutes. The application dated 25th January 2025 seeks for the detention of the respondents herein for a period of 14 days to allow the investigating officer time to complete investigations. The investigating officer avers that they are investigating a case of incitement to violence contrary to section 96 of the Penal Code, that the respondents are persons of interest. They intend to record statements of key witnesses, conduct identification parade, fill P3 form, and conduct mobile data analysis. The respondent's place of abode is unknown, and if released, they might interfere with witnesses. Mr. Odhiambo and Mr. Matoke, counsels for the respondents, opposed the application, stating that the investigations can be conducted in the absence of respondents. They urged the court to be guided by Article 49, 1H of the Constitution. In making my determination, I'm guided by Article 1H of the Constitution, which provides that an arrested person has the right to be released on bond or bail on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. Granting bond or bail entails the striking of a delicate balance of proportionality in considering the rights of the arrested persons who is presumed innocent on one hand and public interest on the other. In considering whether the prosecution has made out compelling reasons so as to warrant denial of bond with respect to the respondents, I will turn to the judiciary bail and bond policy guidelines for guidance on factors to consider in bail decision making. The applicants submit that other than seeking time to complete investigations, that the respondents are flight risks and there is a likelihood that they might interfere with witnesses. However, I find that there is no evidence placed before this court proving that the respondents do not have a fixed place of abode or that they might interfere with witnesses. I do agree with the prosecution. This is a public interest matter, and the respondents have a constitutional right. They have constitutional rights which needs to be protected. In view of the foregoing, the court makes the following orders. The respondents are hereby admitted to cash bail of 5,000 each. The respondents shall report at the police station with the investigating officer on a daily basis. Then we'll mention this matter on the 10th of February for directions. Yes. Yes.
We had a matter this morning, student improvement under page 23. My apologies, Your Honor, kindly requesting that we record the same, the plaintiff and the matter from open court.
Yes, Mr. Matoke. Yes. Yes.
We have an application to make in regard of miscellaneous 2074 of 2025. Your Honor, the third respondent, Mr. Peter Mutonga Wangari, wishes to make an application for the release of his tuk-tuk, which was, when he was arrested, he was driving the same tuk-tuk. We can tell the court the registration number, and I believe the prosecution don't have any reason to keep detaining the same tuk-tuk. We can tell the court the registration number of the tuk-tuk.
So I don't know whether it forms part of the exhibits.
No.
So yes, the same can be released. Oh. So we have to.
Yeah, with your permission.
Most obliged, Your Honor.
Pole ndio hao chukue. Haya mbio. Before we go. Sawa? Haya.